All right. Hello, everybody, and welcome to the Fearless Floyd Show. As always, I am your host, Fearless Floyd. You can reach me at the Fearless Floyd Show at yahoo.com. But the best way to have immediate contact with me, join that group on Telegram. If you want, and this is your choice, you can like, you can subscribe, you can hit the notification bell, you can share this video with anybody you want, or you can immediately change the channel right now and click off this video. If you don't like me, you don't like my channel, you don't like my topic, or you don't like my subject, I'm not tripping, kids. I've said it again. I'll say it a million times. I'm not tripping. So, I don't give financial advice. I don't give medical advice. And I don't give legal advice. Yeah, those three. I do this for fun. And before we even begin, I solemnly swear to tell the truth, the whole truth, and nothing but the truth. So help me God. I just want to give you that little caveat before we begin and do it right up front. So as you see by the title of this video, Chris Hauser lies about jurisdiction. So if I have to go through every statement Chris Hauser has made in each one of his videos on YouTube or in his Facebook group or in his Zooms or on his Telegram group, guess what? I am going to expose a fraud, which I already have, a liar, and a bona fide fraudster. Because that's exactly what he is. Now, I'm sure when I get finished with these videos, his wife is going to thank me. I'm probably going to get a Christmas bonus, a bouquet of flowers. Thank you, Fearless Floyd. I've got my husband back. Only problem is he's still going to have an ego that's as bigger, wider than my screen, that you're not going to be able to sufficiently satisfy, because Chris has an ego now. He thinks he's the shit, and I'm fixing to break it down, kids. Chris Hauser is a liar in the story, a liar, and I'm going to prove it right now. So let me drop this down so I can see where I'm at in my tabs. I can get all of them open in the correct areas where I need them to be. And B. It's buffering. All right. This is John Kennedy French's. Let me know when you update this. Your Facebook page, personal page. Okay. Right here, if you guys you want, you can follow me along. There's the URL. Okay. So we're going to scroll down. It's quite a ways down because there's been a few posts. Right here. Click on those previous comments, and here's the start of the thread. more replies. I don't want to leave anything out so you guys see exactly what I see. And here's Chris Hauser, who he says, who he alleges is the Facebook, his Facebook, his Facebook is a fake account. Is that what he's alleging?
He's alleging that
Telegram?
Telegram is a fake account.
So my Fearless Floyd show on Telegram is a fake account?
No, he's saying that the account that was him on your Telegram was not him.
Oh, yeah. Sure looked like him.
He was saying it's an old profile picture. It's not even his profile picture.
Eh. Well, y'all are more than welcome to go to my Telegram channel, The Fearless Floyd Show, right there. Scroll up to the posts for May Day, May 1st, and click on the little icon for a little picture of Chris Hauser and determine for yourself whether or not you believe it's a fake profile, because it didn't look fake to me. Chris Hauser was a member of my Fearless Floyd Show Telegram group, and poof, he disappeared. And I guess, what's the maxim? He who leaves the battlefield first loses. Just saying. So Chris is no longer a member of my Telegram group. Nobody knows what happened to him. He even was want to say that I would kick him out. I would delete all his posts. And I have not. That's not how we roll around here, Chris. That's how you roll in your groups. Okay? If you hear dissent, you kick them out. They get Karen'd. Holler at you, Karen. Yeah, so yeah, I know, Jesse. I know it's not fake. All right. Yeah, and he continues to call me fearful turd. And do I look fearful? Do I look like I'm scared? Do I look like I'm ready to go sit down somewhere and shut the fuck up? Absolutely not. Here's 11 more replies. Okay, right here. Chris Hauser. Okay, and we actually have four mutual friends. Catherine, who's, I believe, in Jersey. Kim Hutto, who is near Round Rock. So let's just I don't want to click on the profiles, but of course, I haven't added him as a friend. But anyway, so that's proof that's Chris Hauser. So this is Chris Hauser's statement to John Kennedy French. If in fact you did, that would mean you submitted to their jurisdiction 5 times. I don't, this is a quote from Chris Hauser. I don't win case, I get them thrown out for lack of jurisdiction. You're their punk. And of course, he misspelled your. He doesn't know the difference between your and you are. So I'm going to quote this again for you kids, okay? Just so you get the gist of what this whole entire video is going to be about. Chris is replying to John attacking the jurisdiction of his previous legal encounters in Maine. And Chris replied, quote, John Kennedy French, if in fact you did, that would mean you submitted to their jurisdiction 5 times. Don't win case, I get them thrown out for lack of jurisdiction. You're their punk. Unquote. So Chris says that he gets his case thrown out. He doesn't win them, obviously. We're going to see how many cases Chris Hauser, and we're going to go through it one by one until I get to the end. And I'm telling you, telling all of you, and you, Chris Hauser, and all your little followers, all your subscribers, all your Telegram group, your Facebook group, all of you guys, David, every single one of you, okay? Chris Hauser is full of shit. He is lying to your face. Are you ready to watch a show? You want me to kick back for about 2.5 minutes and let you go pop some popcorn? You get ready for this show because it's a show. And I'm going to prove to you that Chris Hauser is a liar. Absolutely. He has not had one case thrown out for lack of jurisdiction or for want of jurisdiction. Okay? Because the Supreme Court holding, damn, I should have looked that up, is that jurisdiction, a jurisdictional defect can be brought up at any stage of the proceedings in any court. Doesn't matter where you're at. Doesn't matter if you're in your trial court, your arraignment court, your appellate court, your post-conviction court. It doesn't matter. Whatever stage of the proceedings you're in, you can bring up a jurisdictional defect. Absolutely. So, let's see if Mr. Hauser, who don't win cases, but gets them thrown out for lack of jurisdiction, actually gets them thrown out for lack of jurisdiction. So what we're going to do here first is we're going to go to the record, because this is the only freaking thing that matters. This is in the Court of Criminal Appeals of Tennessee at Nashville, January 13th, 2021 session. It's filed right here, 32221, Clerk of the Appellate Court, State of Tennessee versus Ronald Lyons, James Michael Usinger, Lee Harold Cromwell, Austin Gary Cooper, and Christopher Allen Hauser. This is an appeal from the Criminal Court of Davidson County, numbers 2017-A-79, 2017-B-1143, Cheryl A. Blackburn, Judge. Okay? And this is the Court of Criminal Appeals number. M stands for middle. 2019 is the year, dash 01946, which is the actual chronological order of this filing, which means it was the 1946 filing into the Court of Criminal Appeals. That's what the CCA stands for. R3 and CD. These are internal codes. Okay? And basically, Ronald Lyons, James, I've already read their names, so I'm not going to read them again. Defendants were named in a 302-count indictment by the Davidson County Grand Jury for multiple counts of forgery and fraudulently filing a lien for their role in filing a total of 102 liens against 42 different individuals with the Office of the Tennessee Secretary of State. Defendant Cooper was also named in a second indictment for 5 additional counts of forgery and 5 additional counts of fraudulently filing a lien. Prior to trial, Defendant Hauser filed a motion to dismiss for improper venue. Okay? Improper venue means you want to change jurisdiction from one court in one county to another court in another county, or to another court in that same county jurisdiction by some extraneous circumstances, i.e., a sovereign citizen shooting in Knoxville at I believe it was an IHOP or a Waffle House that happened right before their trial. And as we well know from the record, Chris Hauser admitted on the record he was a sovereign citizen. So now he wants to claim there's prejudice. So we need to change venue. Okay? I'm not challenging jurisdiction of the court, whether they have personal or subject matter jurisdiction. Okay, personal over me, subject matter over the case. Venue is what he is arguing. Okay, so let's get that clear really quick, because I do not leave loopholes for people to escape through, and I'm not going to leave you a loophole, Chris, because you're not going to get on here and say, "Oh, well, I'll try to move it over here." No, bro. I'm going to prove in this record with the testimony before the Court of Criminal Appeals in Tennessee and the Tennessee Supreme Court. Not once did anybody, you or your counsel, ever bring up the term jurisdiction. Never did you bring it up as an error in your case. You're a fucking liar, Chris Hauser. You don't get cases thrown out. You get convicted and you get your appeals upheld. Okay? And this is what the fuck is happening right here. Yeah, I'm a little mad at you, Chris, because you're calling me names, bro. And the only name I'm calling you is a liar and a fraud, because I can prove it. You're going to have a hard time proving I'm a turd. Believe me, when all said and done, when the dust settles, your wife is going to love me, bro. Your probably whole family's going to love me. So, improper venue, right there. Defendant Cromwell and Cooper joined in the motion. The trial court denied the motion after a hearing. After a jury trial, each defendant was convicted as charged in the indictment. The trial court sentenced defendant Cromwell to an effective sentence of 25 years, defendant Cooper to an effective sentence of 50 years, defendant Lyons to an effective sentence of 22 years, defendant Usinger to an effective sentence of 21 years, and defendant Hauser to an effective sentence of 20 years. After motions for new trial and several amended motions for new trial were filed, the trial court held a hearing to be a motion for new trial. The trial court denied the motions in a lengthy and thorough written order. Each defendant appealed, raising various issues, challenging their convictions and sentences. Okay? Nowhere in that sentence do you see personal and or subject matter jurisdiction. Do you not? No. And guess what? You're not going to. So if you don't even want to watch the rest of this video, more power to you. Okay. I just gave you the, what do they call that? When you give the details of the movie? No, not the synopsis. I think no. Where you reveal how the movie ends. Spoiler alert. Yeah, okay, there you go. Spoiler alert. Okay, so I gave you the spoiler alert because this video is going to clearly, it's going to follow this right here. This one little sentence. Each defendant appealed, raising various issues, challenging their convictions and sentences. After a deep review, we affirm all judgments and all sentences. So never once in those two sentences do you see anything to do with personal or subject matter jurisdiction. Okay? And you're not going to at any time. So if you don't want to watch this video, you don't want to hear the testimony or arguments of Emma Tennant before the Court of Criminal Appeals and before the Tennessee Supreme Court in her own voice, because she represents Chris Hauser, because Chris Hauser is mentally incompetent, okay, to conduct his own affairs. So he has a public defender representing him before the court because he is brain dead. He is a legal moron. I'm trying to express this to you. This guy has no business opening his mouth, expressing anything about legal, criminal, appellate, post-conviction. anything to do with law. He needs to shut the fuck up. He is stupid. Okay? And I'm going to show you. I'm using his own words against him. Okay? Because I have the record. And when it comes to legal matters, everyone will tell you who has anything or any knowledge about how the judicial system works in America, only the record counts. Okay? Because when you go in and you look at his case record, you're going to see what the Tennessee Supreme Court went and got. The appellate record. You're going to see what the Court of Criminal Appeals went and got. The trial record. The trial record consists of the clerk's record and the reporter's record. Combined, those become the appellate record. Okay? So when they go to Tennessee Supreme Court, they get the appellate record from the Court of Criminal Appeals. Absolutely, that's how it works, Chris. Okay? Are you learning something? Because obviously you can't go get a book like this. Okay? Okay? That's state. This is federal. You got to read, bro. You're checking the 1099A process. Are you trying to free? Are you really trying to overturn your conviction? Or are you just allowing somebody else to do it for you like you're doing with the 1099A? And then claiming it's all yours, that you created it. Well, Chris Hauser, I got news for you, bro. You're so full of shit. I'm surprised you're not black as coal. So, Timothy Easter delivered the opinion of the court, which Robert W. Whittemire and Robert L. Holloway Jr. joined. Okay, so this is what they call a panel hearing, because it takes 3 justices or judges on the appellate level to create a panel. So you can do a panel hearing, and then if you had a smart attorney, which you don't, you think you do, okay, you could have done a motion for rehearing en banc. You know what that means, Chris? You're a fucking moron. Motion for rehearing en banc means, okay, I got the opinion of these 3 justices, but there's 4 more on the court, or 5 more, or 6 more. I don't know how many are on the Court of Criminal Appeals. En banc means you want the whole court to review it. So, in fact, you have a second chance that you might have got 3 judges who saw it, or justices who saw it one way, but those other ones who could actually overturn that opinion and rule in your favor. But your attorney didn't do that, did she? You didn't tell her to do that, did you? Because you didn't even know about it. Because you're a legal moron. Stop, Chris. You think you're some kind of legal genius? You don't know jack frickin' shit about how appellate review works, or the entire appellate process. You're a moron. Clearly, because you have a public defender. And anybody who gets on YouTube and states, I'm a multi-millionaire and has a public defender, clearly you must be lying, because multi-millionaires don't take on public defenders. They go get the best defense counsel in the world, like O.J. Simpson. So, Chris, again, I'm going to expose you every step of the way. You open your mouth, I'm going to expose it as a lie. By the record. All right, here we go. Emma Ray Tennant on appeal. Assistant Public Defendant Martisha Johnson, District Public Defender Jarrett Mollenkoff, and Stella Yarborough at trial. Assistant District Public Defenders, Nashville, Tennessee, for appellant Christopher Allen Hauser. Christopher Allen Hauser had a team. 1, 2, 3, 4. 4 attorneys representing Chris Hauser. All public defenders, actually assistant public defenders. Okay, that's what Chris Hauser, the multimillionaire. So I guess if you're, I don't know, what are you a multimillionaire of? What kind of assets make you a multimillionaire, Chris? Blades of grass, reeds of hay. Yeah. Oh yeah, I got millions and millions and millions of stalks of corn out here. So I guess you're a multimillionaire. You got to hire a public defender. So not going to beat that up. Here's the opinion, because this is the only thing that matters. On January 30th, 2017, the Davidson County Grand Jury returned a multi-count indictment containing 302 counts that named 8 defendants: Michael Robert Birdsell, Victor D. Bunch, Austin Gary Cooper, Lee Harold Cromwell, Christopher Allen Hauser, Ronald James Lyons, Mike A. McConnell, and James Michael Usinger. All of the odd number counts of the indictment charged an individual defendant with 1 count of fraudulent filing of a lien in violation of Tennessee Code Annotated Section 39-17-117, while all even numbered counts in the indictment charged forgery in violation of Tennessee Code Annotated Section 39-14-114. Each count of the indictment referred to only one of the defendants and named one victim. In May of 2017, defendant Cooper was named in an indictment in case number 2017-B-1143, charging him with an additional 5 counts of forgery and 5 counts of fraudulently filing a lien. All of the counts in both cases were based on the electronic filing of Uniform Commercial Code (UCC) financing statements with the Tennessee Secretary of State's office in Nashville against various individuals. Okay. Defendants Cooper, Cromwell, Hauser, Lyons, and Usinger were tried together. Counts 51 through 70 of the indictment pertain to defendant Cooper. Counts 71 through 98 to defendant Cromwell. 99, 140 to defendant Hauser. 141 to Lyons, Usinger. Prior to trial, defendant Hauser filed a motion for change of venue. In the motion, defendant Hauser asked the trial court to dismiss the indictment for lack of venue in Davidson County because no element of the offenses charged in the indictment was alleged to have occurred in Davidson County. Defendant Hauser alleged the electronic submission of documents from another county did not subject him to venue in Davidson County. Defendant Cromwell and Cooper filed motions joining defendant Hauser's motion for change of venue. All right, first, there's a difference between venue and jurisdiction. And if you want, I'll look it up in Black's Law Dictionary. But you can take my word for it because I'm telling you under oath. Or I can just go to State Rules of Court and we can address it there. So this is going to be a long video. I don't want to get into all of that. It's a beautiful day. I want to go outside and enjoy it. First, I need to get warm on the fire. That is Chris Hauser's corpse burning before your eyes. Okay, so clearly somebody doesn't know the difference between venue and jurisdiction. So we're gonna go. The trial court held a hearing on the venue motion. The trial court asked at the outset of the hearing why venue was an issue being dealt with prior to trial because, quote, the jury has to find venue, unquote. The 3 defendants joining in the motion, defendant Hauser, Cromwell, and Cooper, argued that venue in Davidson County was improper because the liens at issue were not filed in Davidson County. Specifically, defendant Hauser asserted he electronically filed the documents pertaining to the courts charged against him in Coke County, and while defendants Cooper and Cromwell claimed they electronically filed documents relating to their charges in Anderson County. Okay. Again, as I've clearly stated, what did Chris Hauser just do? Chris Hauser, quote, asserted he electronically filed the UCC1 financing statements pertaining to the counts charged against him in Coke County. He just admitted his guilt. Sorry, kids. Pretty much for me, absolves every issue brought up before the court. He admitted his guilt. Do we even need to have a jury trial now? Okay. Let's see. Each defendant claimed venue was thus improper in Davidson County. The state disagreed, arguing that pretrial litigation of venue was improper under Tennessee Rule of Criminal Procedure 12b-1. At the conclusion of the hearing, the trial court took the matter under advisement. In a thorough written order, the trial court denied the motion, finding that the state had to prove that one element of each offense occurred in Davidson County and the fact that dockets had to be filed at the Secretary of State's office in Nashville, even if electronically established venue in Davidson County. Okay, and we can go in here with the proof of trial. Y'all want to hear all this. I've already read this ad nauseum multiple times. Okay, but I wanted to go over that because Mr. Legal Genius, Chris Hauser, okay, doesn't differ between jurisdiction and venue. Okay, his jurisdiction would abolish the case. That's not what they argued. They argued venue. In fact, I'm going to do it. Venue. Common law pleading and practice. A neighborhood. The neighborhood, place, or county in which an injury is declared to have been done. The fact declared to have happened. That is in 3 Blackstone's Commentary 294. The particular county or geographical area in which a court with jurisdiction may hear and determine a case. Venue deals with the locality of suit, that is, with question of which court or courts or those that process adequate personal and subject matter jurisdiction may hear specific suit in question. Okay? A lot of times people will, or defense attorneys will file or even in civil cases, they will file a motion to change venue from one county to another due to local newscasts that will potentially prejudice potential jurors. Okay, so that's what that's all about. Let's see. And here's where they, Mr. Burton, who was the expert for the Secretary of State's website. These exhibits contain financing statement documents, generally including UCC1 financing statement, the company acknowledgement page, UCC3 amendment to the financing statement and the acknowledgement page. Hang on 1 second. Hey, bro, talk to you right now. I'm doing a Zoom. Yeah, and somebody drove after I told them to drive last night after they've been drinking in their garage. I'm not going to mention any names. Yeah, I try to save as many people as I can. Can't save everybody. Some people don't want to be saved. They're just begging to go to prison. So anyway, let's see, payment documents, receipts, and in several cases, documents concerning the termination or removal of the financing statements. During the admission of each of these exhibits, Mr. Burton testified similarly. He described the UCC-1 financing statement as the document submitted electronically. He testified to the name and address of the person submitting the document, the names and addresses of the debtor, the secured party, and the collateral description as entered by the submitter as reflected on each document. The amount listed on each lien varied from $4 million to $12 million. One example included the following language in the collateral description: claim of lien. Okay? Now, Chris has said that he didn't file liens. He filed UCC-1 financing statements. So if you wrote in the collateral box, claim of lien, May 23rd, 2016, in the amount of $8 million in the money of account or in lieu of the money or in Federal Reserve notes or a bank draft to the United States dollars of whatever currencies prescribed, lawful currency and satisfaction of all debts, public and private, and the county in which this claim was executed. Okay, does that not say lien? Chris, bro, man, why do you want to lie to everybody? I mean, you can actually go on the Secretary of State's website for Tennessee, and guess what? There's not one UCC filed in Chris Hauser's name. Not one. They pulled every one of these. I'm pretty sure he's probably banned for life from filing a UCC-1 in Tennessee. That would be my presumption. This particular UCC-1 listed the maximum principal indebtedness as $0. The UCC-1 was accompanied by a UCC-3 amendment to the original financing statement and related payment documents. This particular UCC-3 assigned a UCC-1 to the U.S. Treasury in Washington, D.C. Mr. Burton explained that the lien based on the UCC-1 lapses after 5 years unless submitter files a continuation within a 6-month period, extending the UCC-1 for an additional 5 years. There's no real mechanism in place to get the lien removed. Okay, you see they're using the term lien over and over and over and over. In all, defendants Cooper, Hauser, Lyons, and Usinger each filed liens purporting to have a $12 million possessory interest in the property of the following individuals. Okay, and this is why, no matter what reversible errors you have that are valid, Chris Hauser and Cooper and Lyons and Usinger, your case is not going to get reversed. Not in Tennessee, because of the people you filed it against without any security interest or security agreement prior in place. Okay? Buddy Bradshaw, the county mayor of Loudoun County. Mark Brown, an attorney from Knoxville. Michael Menifee, Mr. Brown's law partner in Knoxville. Michael Pemberton, a circuit court judge for the 9th Judicial District of Tennessee. John Weaver, chancellor for the 6th Judicial District of Tennessee. Tim Burchett, the mayor of Knox County. Howard Hogan, clerk and master of Knox County. Lisa Niles, circuit court clerk for Loudoun County. And Ron Woody, county executive for Roane County. Are you seeing a pattern here? Okay, defendant Cromwell filed liens against James Akaji, the chief of police for the city of Oak Ridge. Victoria Bannock, an assistant district attorney. Dave Clark, the district attorney general for the 7th Judicial District. Donald Elledge, the criminal and circuit court judge for Anderson County. Grant Gouldy and William Jones, the circuit court clerk for Anderson County. Defendant Cromwell also filed liens against these same individuals for $4 million. Defendant Cooper filed liens against Roger Miller, a general sessions judge in Anderson County, Mr. Clark and Mr. Jones for $4 million. Defendant Lyons filed liens claiming $6 million possessory interest in the property of Rhonda Day, the city court clerk for Morristown Police Department. Bill Gibbons, commissioner for the Department of Safety and Ronald No, a lawyer in Morristown. Roger Over, chief of the Morristown Police Department. Matthew Sexton, municipal court judge in Morristown. Reed Spalding, Richard Webb, an officer with the Morristown Police Department. Defendant Lyons filed additional liens claiming $6 million possessory interest against Ms. A, Mr. No, Mr. Overholt, Judge Sexton. Defendant Cooper also filed liens against Commissioner Gibbons, blah, 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 Susan Lowe. Defendants Cooper, Hauser, Usinger also filed liens against Tracy Trott, the commander of the Tennessee Highway Patrol. Defendant Hauser and Usinger filed a lien against David Perkey, Commissioner of Safety and Homeland Security for the state of Tennessee, for $4 million. Defendant Cooper filed liens against Don Layton, a general sessions judge in Anderson County, and Paul White, the Anderson County Sheriff, for $4 million. Defendant Cromwell filed liens against Judge Roger Miller, Ben Higgins, a special investigator with the Oak Ridge Police Department, for $4 million. Defendant Hauser filed liens against James Acuff, Lou Ann Ballou, Telford Fogarty, a chancellor and 4th and 5th Judicial District of Tennessee, Jeffrey Green, a lawyer from Coke County, Raquel Hatter, Melissa Hauser, Defendant Hauser's ex-wife, retired Circuit Judge Ben Hooper, Peggy Lane, Judge Dwayne Sloan, Judge Richard Vance, for $4 million. Lastly, Defendant Usinger filed liens against K. Solomon Armstrong, the clerk and master of Greene County, Joy Nunley, the Register of Deeds of Greene County, and John Stills, a deputy in Greene County Sheriff's Department. So, those are the ones that actually went to trial. There were other ones they just abandoned because they didn't want to drag God and everybody into court to testify when they have not only Chris admitting his own guilt along with his co-defendants, to have these people come in and testify. And you see these are like upper echelon, political, elected, appointed, and employed figures in the state of Tennessee. So do you really think that somebody like the clerk and master of Greene County, Joy Nunley, a registered of deeds, John Stills, a deputy for the sheriff's department, the commissioner of safety and homeland security for the state of Tennessee, municipal court judge, city court clerk, I'm just scanning through these, chief of police, district attorney general for the 7th Judicial District, sixth judicial chancellor for the 6th Judicial Judge, circuit court judge. Okay? Those people are the contemporaries of the Court of Criminal Appeals and the Tennessee Supreme Court. Do you seriously think they're going to allow this to be overturned? So just anybody can wantonly go to the Tennessee Secretary of State's office and file fraudulent, baseless UCC-1 financing statements, i.e. commercial liens on anybody they want for any amount they want without a security interest or a security agreement being in place? Do you really think that's going to happen? You really think Chris Hauser is going to prevail? Right there, there's the memorandum opinion. And I'm just going to go ahead and scroll down to the bottom. Okay. Defendant Hauser argues that the trial court erred in applying enhancement and mitigating factors. Enhancement and mitigating factors are advisory only. See Tennessee Codes annotated section, blah, blah. Even if the trial court improperly applied an enhancement or a mitigating factor, Defendant Hauser's sentence will be upheld as long as it is consistent with the purposes and principles of the Sentencing Act. The trial court did not abuse its discretion in sentencing defendant Hauser to a within-range sentence after following the procedures set forth in the Sentencing Act. Defendant Hauser is not entitled to relief on this issue. Okay? And I can go on and on and on and on. And this is about defendant Hauser right here. This is the only thing I got to say here in this. Defendant Hauser had a separate sentencing hearing on the same day, okay, because criminal trials are bifurcated. They're two parts. You have phase one, the guilt and innocence phase. You have phase two, which is the sentencing phase, and they're completely different. Okay. Defendant Hauser had a separate sentencing hearing on the same day. He was convicted of 21 counts of filing a fraudulent lien and 21 counts of forgery. Agent Irwin testified that defendant Hauser also filed liens against entities that were not included in the indictments. These liens were filed against Knox County government, Loudoun County government, Tennessee Department of Safety and Homeland Security, Circuit Court of Coke County, and Tennessee Department of Human Services Child Support. Defendant Hauser's mother, Mary Hauser Larson, testified that defendant Hauser's behavior was not indicative of the way he was raised. She apologized for his actions. I got your mom apologizing for you. She acknowledged that defendant Hauser was in the Army. Ms. Lawson was not under the impression that anyone was hurt by defendant Hauser's actions. Well, Ms. Larson, maybe somebody should file a lien against you, and then you can go try to get you a car and see if you're not harmed or injured by that process. That would be fraudulent. Rebecca Hauser testified that she was married to defendant Hauser. She explained that defendant Hauser changed after he met defendant Cooper and paid defendant Cooper, Chris Hauser paid defendant Cooper $6,500. Defendant Hauser informed her of the actions he was taking when he filed the liens, but she did not understand it. She claimed that if he knew it was illegal, quote, knew it was illegal, he wouldn't have done it, unquote. Now, hold on. Let's back up here. Who did he file this lien on? Tennessee Department of Human Services Child Support. Why? Because Chris didn't want to pay child support. Instead of paying child support, Chris paid defendant Cooper $6,500 to file fraudulent liens to basically send Chris to prison, instead of giving $6,500 to Rebecca Hauser for child support to take care of his own kids. Yeah, Chris, you're right. You don't have time to play with children anymore, do you? That's the Chris Hauser I know, kids. Okay? That's who he really is. I'd rather pay somebody $6,500 to send me to prison for filing fraudulent liens than give it to my own children. You're a winner, Chris. Y'all keep following that guy. Okay? He's a good guy to follow, right? He's honorable. He's truthful. He operates in good faith and clean hands at all times. Everything he tells you is under oath, right? Is that the Chris Hauser we all know and love? I'm just asking you, kids. Okay? Defendant Hauser testified that he was in the Army. Okay? Chris Hauser testified. He was discharged in 1990. He recalled that he injured his knee in the military in an auto accident, and after leaving the military, fell 40 feet off a cliff and received significant injuries. Since that time, he reported being disabled. Defendant Hauser also reported dealing with post-traumatic stress disorder as a result of his military service. Defendant Hauser claimed that he planned to start a nonprofit called Veterans Adventures. Defendant Hauser explained that he got divorced from his first wife after his fall. At that time, they had 2 small children. Defendant Hauser eventually became frustrated with how, quote, child support was going, unquote. When he met defendant Cooper, he became interested in the process of filing liens. Christopher Hauser paid defendant Cooper $6,500 for help. He explained that he thought what he was doing was legal. He admitted that he did not know all of the people against whom he was securing liens. I swear to God, if I wasn't reading this record and I was just stating this, y'all wouldn't believe me. But here it is. Christopher Hauser testified, okay, he admitted that he did not know all of the people against whom he was securing liens, and that he provided his credit card information for filing the UCC documents instead of paying Rebecca, child support for his own two kids. You're a winner, Chris. We're actually seeing who the real turd in this diametric really is. In sentencing Chris Defendant Hauser, the trial court noted that he had a previous history of criminal convictions in addition to those necessary to establish the range based on his arrest for violation of an order of protection and other events that were not charged in the indictment. The trial court agreed that Defendant Hauser's conduct neither caused nor threatened serious bodily injury. The trial court declined to apply several enhancement factors and at least one mitigating factors. Okay, the trial court declined to apply several enhancement factors and at least one mitigating factor. The trial court sentenced Defendant Hauser to 2 years for each of the 21 fraudulent lien convictions and 20 years for each of the 21 forgery convictions. As to consecutive sentencing, the trial court determined that Defendant Hauser had an extensive criminal history. Okay, I have no idea what that looks like. Don't even care. The trial court declined consecutive sentencing, ordering the sentences to be served concurrently for a total effective sentence of 20 years. The trial court denied alternative sentencing for Defendant Hauser on the basis that it would depreciate the seriousness of the offense and would deter others. Okay? This is exactly what I'm talking about. This case, Chris Hauser's case, and all these co-defendants, fault partners, is not going to get reversed. Ever. Okay? And I just showed you why. The trial court denied alternative sentencing for Defendant Hauser on this, that it would depreciate the seriousness of the offense and would deter others. That means, hey, any of you sovereign citizens or others who don't want to be sovereign citizens and want to file fraudulent liens on our brethren, oh, we got something for you. And here's the perfect example. Christopher Allen Hauser. Okay? And here we go. Tennessee courts, appellate case search. State of Tennessee versus Ronald Lyons, James Michael Osinger, Lee Harold Cromwell, Austin Gary Cooper, and Christopher Allen Hauser. Here's the number, okay? And you can click on any one of these and it'll tell you everything that's in there. So the reason I did this is, to show you that this is the date the appeal was filed, the record filed, because that's the only thing that matters is the record. Appellant's briefing complete. Appellee's briefing complete. Oral argument submission. Here's the panel, just like I explained, a panel. Decision date, opinion, they affirmed it. Appeal to the Supreme Court, 419. Okay, here we go. Hauser, Christopher Allen, appellant, defendant, counsel, Emma Ray Tennant. Okay, doesn't say pro se, doesn't say pro per, counsel. Okay, so we can go down here, right here. Petition to read here, Christopher Allen Hauser. You can click on this, it'll download it, you can go read it. So if it has a PDF right here, that's what you can do. Okay, so you can scroll down, you can open all these up, read them if you want. Brief, appellant's brief filed, and I wish that had a PDF because I sure would like to read that. Oh, yeah. Motion for extension to file brief, because Appellate record checked out by Emma Ray Tennant. Appellate record checked out. Emma Ray Tennant. You know why she checked out the appellate record? Because it's the only thing that matters. The record. Okay, so you can click on all this if you want. Scroll down, check it out. Case milestones, tells you everything that's happening. Parties, counsel, again, document history, same thing. Record information, 103 exhibits. Okay. Basically same thing. But I believe this is the Tennessee Supreme Court. Lee, Bivens, Kirby, Page, and Campbell. Yeah, this is the panel for the Tennessee Supreme Court. Yeah, this is it. Okay. Basically, this is the same. It's like the docket sheet. Okay. Did you answer the letters? Briefs filed. That had a PDF, but it doesn't, so I can't read it. So here we go, kids. Get past this commercial.
That would be my argument as to that, Your Honor. I'm not sure exactly how much time I have left.
Mr. Rush, you are just into your rebuttal. So,
well, if there are no other questions specifically, then I'll just leave it at that and reserve the balance of my time for rebuttal, please.
All right. Thank you very much. Ms. Tennant?
Good morning, Your Honors. May it please the Court, my name is Emma Tennant of the National Public Defender's Office. I am appearing in the case of Mr. Christopher Hauser. I would like.
Okay. What should be the first thing out of her mouth after that? Jurisdiction, right, Chris? Isn't that what you argued? I get cases thrown out on jurisdiction? Well, let's see what your counsel, your represent, because you're mentally incompetent, has to say about that.
I'd like to reserve 3 minutes for rebuttal time, please.
Certainly.
Thank you. Your Honors, I would first like to address, as Mr. Russ stated, the law of forgery and why I believe the concept of a false making has survived the 1989 rewrite of the forgery statute. After I go through that, I'd like to drill down a bit into the exact nature of these documents, the statements, to review what under the law they actually are, what their legal import and significance actually is. I think that the examination to assessing their value if this court decides that they can in fact be forgeries. And finally, should time allow, I would like to address the issue concerning the labels put on some manila folders to house the exhibits at trial, and why referencing an amount, a filing amount on those labels constituted an improper and prejudicial comment on the evidence by the trial court. I will not likely have time to address sentencing, but will rely on the arguments set forth in my brief as to why Mr. Hauser's 20-year sentence is excessive. First, with forgery, Your Honors, the forgery.
Okay, you just heard all the issues that she's going to argue before this panel. Did you hear anything about jurisdiction? Did you hear that word, jurisdiction? Did you hear, I want to challenge the personal and or subject matter jurisdiction in this case? You did not. And you're not going to. Because Chris Hauser does not get cases dismissed for want of jurisdiction. He does not get them thrown out. He does not win in court. He's a loser. Loser! You are, Chris. You're a loser. You lost here. You're going to lose in the Tennessee Supreme Court when I play that too, because we're going to hear Emmy talk again, and we're going to hear her in her own voice not argue jurisdiction. Okay? So I don't have to play this whole thing for you because you just heard everything that she's going to argue before the court that was presented in apparently their brief. So thank God I don't have to go through that. I can go enjoy my day. So this is the Tennessee Supreme Court right here. And you can see YouTube. Y'all can go watch this. Tennessee, State of Tennessee versus Ronald Lyons, Judge Michael Oetzinger, et al. And Christopher Hauser's in that et al. I'll blow that up. Okay. And that is the dais. And these are the justices being impaneled.
All right, welcome everyone. We're ready to start our third case for the morning. Mr. Hibbert, you may call the case.
Okay. The proceedings have begun. He's fixing to call the style of the case. Okay. And there's a camera back here behind these justices. And that camera is going to come out here to the audience. And you're going to see Chris Hauser. And I want you to listen to everything Chris Hauser has to say. Okay? Because we're going to see if Chris Hauser personally raises any question, argument, or even opens his mouth about personal and or subject matter jurisdiction before the highest court in Tennessee. Here's your chance, Chris, to stand up, stand on your square, and present your case as a mental competent. Are you going to do it? Do you have some cojones essay, or do you have to have somebody come represent you because you're mentally incompetent and cannot handle your own affairs? Like you don't like to pay child support to your own child. You'd rather give it to somebody to go send you to prison because you're an idiot.
State of Tennessee versus Ronald Lyons, James Michael Oetzinger, Lee Harold Cromwell, Austin Gary Cooper, and Christopher Allen Hauser.
Mr. Rice,
Good morning, Your Honors.
You're going to be arguing along with Ms. Tennant, is that correct?
That's correct. I am representing Mr. Ronald Lyons. She's representing Mr. Hauser. We also have Mr. Krieger, Mr. Edwards, and Ms. Wright, who are all here for the three other defendants.
Nice, welcome.
Mr. Edwards, sorry. As far as the division of labor, I would like to argue for approximately 15 minutes, and I'd like to reserve 2 minutes for rebuttal, and I'll do my best to keep my eye on the clock and not run over. Ms. Tennant's going to be arguing for the remaining portion of the defendant's time. I'm going to primarily focus on...
Here he is right here, Mr. Can't Be Shaky. Okay? And Chris, I didn't Photoshop this, okay? This is the real deal, bro. So you can listen to this guy. This guy has no business being an attorney. He has no business being in the Tennessee Supreme Court arguing whether or not the floor should be swept. This guy's trash. So let's just watch Chris Hauser's actions.
On the terms in this forgery statute, she's going to primarily focus on the valuation issues that were raised in our briefs. We're here focused on 3914, 114B1B, and the primary thing that I want to argue is that there is ambiguity in the term false, in the phrase false entry in a book or record. False is a term that has multiple meanings, but a very clear meaning is genuine. It also can mean something that is intentionally untrue. In fact, those are the definitions in the dictionary, at least online it is. And because the term false could mean not genuine and not simply untrue, that creates an ambiguity in the statute that I've just referenced as to a false entry in a book or record. And I think because that's the case, this court is going to be required to interpret what the legislature meant when they use that term false and whether the conduct of the defendants thereby violates the statute.
So you're saying these lien documents are genuine?
I'm saying they're genuine documents that contain lies. And that gets into a very long, and I'll try to be.
Genuine documents that contain lies. So what this guy just admitted is that these guys up here file genuine documents that contain lies. Do you see a pattern going on here that this gentleman right here is associated with? Lies. Okay? I didn't put words in this guy's mouth.
As succinct as possible. A forgery is a document that is false in its making. I think the best example that I can make is, or at least the most succinct one, if I wrote a check in my checkbook and I tried to pass it to anybody, and I knew that there was insufficient funds in my account for that check cover, that is a crime.
That doesn't a different subsection of the forgery statute cover that sort of false making?
Well, in the particular example of the check, yes, but in order to try to interpret or explain the nature that forgery requires false making is the reason I was using the example. But yes, it's under subsection A, well, B1A rather than B1B. And I'll discuss it a little bit later. I think the state...
And I can keep going on with this because right here, you don't see Chris Hauser standing up saying anything, do you? He's sitting there like the fraud that he is. So we're going to bump it up to right here. And this is where he's finished his arguments. And the illustrious Emma Ray Tennant is going to argue before this panel on behalf of Christopher Allen Hauser. So I want you to listen carefully. The words coming out of her mouth. I want you to listen for one word: jurisdiction.
May it please the court, I am Emma Ray Tennant of the Nashville Public Defender's Office. I am here on behalf of my client, Mr. Christopher Hauser, and as Mr. Russ noted, I would like to reserve 2 minutes of my time for rebuttal. Listening to Mr. Russ right now describe the ambiguity of the statute just really brings home that there are two, if not more, meanings of the word false that we do use in natural parlance every day. We can speak of, on the one hand, a false statement or false testimony. If there's false testimony, we all know that that means a witness has lied. On the other hand, we can speak of false coinage or false teeth. On the both of those references refer to inauthentic things. We know that we don't speak of teeth that lie. We speak of teeth that are not genuine. That means we have to look behind the actual text of this provision to determine its meaning. And as Ben noted, both the legislative history and the broader statutory scheme show us that this provision was enacted to protect authenticity and not accuracy, and to insert an accuracy prong into the forgery law would unduly expand forgery beyond its intended scope. As the law stands right now, it is not clear what it means. It is a crucial component of statutory interpretation that no individual be forced to speculate at peril of indictment what it is that a law means. And that is what has happened here.
In order for your client to prevail, do we have to adopt your interpretation of false, or is there another argument on which your position hinges with respect to the interpretation of the statute?
I think to best illuminate what the legislature intended is to adopt our provision, our interpretation of the word false, because I think that the statute is designed to protect authenticity. It is situated in the criminal code right before the criminal simulation statute. They work in pari materia. They have similar goal, similar scope. Criminal simulation protects the authenticity of things, objects, antiquities, paintings, that nature. Forgery protects the authenticity of writings.
But doesn't the argument, I guess to me, it's very important how we interpret books or records, and I guess really the whole phrase in books or records. I mean, on one view, the book or record could be sort of the entire kind of record of the Secretary of State's office related to, this collateral or this individual. And that, if that's the case, then the inauthentic, the false entry, which you interpret to be inauthentic entry, could be sort of this entire financing statement, marring the authenticity of the Secretary of State's record. So it seems to me that one could adopt your interpretation of false and still find that there was a forgery here, depending on the interpretation of books or records.
And I agree with you, Justice Campbell, that books or records is also not defined in this provision or more largely in the criminal code. As I will get to when I talk about value a little bit more, I would suggest that on these facts, in this case, that the answer to your question is pretty easy because no one gets to really rely on the authenticity of filings in the financing statements in the Secretary of State's office. We have case law which demonstrates that those financing statements serve a purpose to provide sufficient notice so that third parties can more completely investigate what they actually mean.
But doesn't it signify, though, that if somebody files a UCC-1, it signifies that they believe they have a real claim as to this collateral. It signifies to the world that this person is asserting a real claim as to this collateral. But here you have the additional element, though, the intent element, that they put false information into a financial statement with intent to harm. And it actually does do harm sometimes, doesn't it?
It does do harm, and it was criminalized by the legislature in 2012, and then they looked at it again in 2013. The law that has already been recited here, 39-17-117.
But that statute doesn't actually require intent to harm, does it?
Intent to encumber, I believe, is the language in that statute, where there's no unauthorized or legal base. Where there is no authorized reasonable basis or legal claim. The financing statement standing alone, however, only indicates the possible existence of some kind of underlying claim. It is merely a notice document, and in fact, this is a good opportunity, I would think, to delve.
But these are not even possible, are they?
Third parties rely on those,
yeah,
oftentimes for financing decisions and everything else.
They rely on them, but they also have a duty to investigate further to clarify the exact nature of the relationship between the secured party and the alleged debtor. The notice filing laws in our state and in the UCC nationally have become more and more simple over time because of a specific policy goal of making financing statements and notice of the possible existence of this claim as simple as possible. A financing statement includes and requires very little information. It is described as skeletal. It requires authorized information, and in fact, when someone goes to fill a financing statement, they are put on notice. It's one of the first 2 or 3 computer screens that a filer encounters is notice that an unauthorized financing statement, an unauthorized filing will break the law 39-17117, Class C felony. They're not put on notice that it may be a perjured or forged filing. But yes,
What did she just say? Did she just not say that you get a warning from the Secretary of State's office in the business or UCC filing section when you're filing a UCC-1 that it could be forgery? Did she just not say that before the court? Just admitted it. See, this is what happens when you get somebody to represent you who doesn't know what they're doing. Because she just got up there and admitted the forgery. Oh, yeah, well, it says it could be forgery, and that's what they're talking about. Did it cause harm and injury? She admitted to that.
It should be, it must be authorized to meet with the law, of course, Justice Bivens. But these are very simple documents. They are designed to have as little information as possible, reducing transaction costs for secured parties, and putting the duty on the world, the third-party creditors, the next in line in a queue of potential creditors, to look behind the financing statement and see what the terms of an underlying security agreement actually are.
Would you say that under, because the statute is section 3911-106A39, this is kind of the definition of
Value definition.
Right. Would you say that a financing statement is a document constituting evidence of a debt within the meaning of that provision?
I think that on the one hand, under looking at what it is, yes, we can very reasonably see it that way. Part of our revenue laws, recording tax statute, expressly calls a financing statement a document evidencing a debt. Yes, yes, Your Honor.
Anybody seeing that financing, ignore it. Say they have it on. In the real world, they just, someone may look at that and think, well, this is inappropriate. This was obviously made up. This judge doesn't owe this person $13 million or whatever.
In the real world, not the fantasy world that Chris Hauser lives in, okay? This judge right here, okay? This is the real world we're dealing in. So don't do it again. We're going to uphold the lower court opinion.
Whatever it is, they can't just ignore it.
By the way, I'm still waiting to hear that one key word, jurisdiction. Have you heard it yet?
To do so would be at their own peril, and that's I guess why this statute was passed.
Absolutely, Your Honor, and it does cause problems for both the people named as alleged debtors and anybody, yes, who's looking to determine if a given collateral is already tied up with some debt. That is exactly why the legislature met twice in two sequential years to hammer out a solution to unauthorized filings.
That's why the legislature met twice. First to create a bill so it would be signed into law. Then they went back and amended the law so it covered more ground, so they would be better well protected from people like this idiot filing fraudulent liens, which she tries to cleverly mask as unauthorized. Okay, so what she should be saying is illegal or fraudulent or unsecuritized. Okay, so that's what lawyers do. They misspeak purposely. Okay, so you're hearing her argue in front of the panel, and she's not under oath. She doesn't have to tell the truth. Okay, nobody in this courtroom is sworn to provide truthful testimony. Everything that's going on in here is fiction. This is a 3-ring circus. Okay, this is one ring, the panel's the other ring, and the next guy you're going to see up, well, you're probably not going to see him. I'm going to skip over him. That would be the state's attorney. That's your 3rd ring. So right here, everybody's putting on the court jester hat and playing their part. So we're listening for one key word, Chris, because if you want, you can get on the chat right now And you can tell us at what point in this hearing is she going to start arguing jurisdiction? Or when are you going to stand up as a man, as a free man, and challenge the jurisdiction?
But to Justice Bivens' point earlier, why could somebody not be prosecuted under either statute, either the one that you just referred to, that the legislature specifically crafted to address this, or the forgery statute, which requires a higher level of intent, has different elements?
I don't think that there's any reason, if it meets, of course, if it meets the elements, that they couldn't be prosecuted under both. I think in my briefing,
If it meets the elements, they could be prosecuted under both. That is what it's all about. Is the state has the burden to prove the elements of the offense as charged before a trier of fact, which could be the jury or the judge, depending on if you have a jury trial or a bench trial. It's up to them to determine the facts, whether the defendant is innocent or guilty of the charge. That's how it works.
noted the existence of the unauthorized filing statute in many locations to help as an interpretive tool for the legislature, the intent of the legislature as to both provisions. Forgery is a law that means one thing and no more. As with every law, it has to have a boundary to it. It has to have some reasonable cordon. The same with the unauthorized financing statement or unauthorized filing of a financing statement. Those laws have coordinates; they must. But and part of this court's job will be to interpret what the cordon of forgery is, and if it includes the conduct here. If it does, of course, I don't think there's any basis for saying they couldn't be prosecuted under both. I think
I think Ms. Russ indicated you were going to address.
I really would like to address value if I may.
Address that for us, yes.
My primary position on value is that under the law and under the policy of the UCC, these are mere notice documents. They do not create a legal relationship. There has to be an underlying security agreement to do that.
There has to be an underlying security agreement entry in place. Correct? You're hearing it out of her own mouth. I'm not making this shit up. Okay? Because Chris Hauser right here, every one of you, all that comes out of that little purty mouth he's got, just ask those boys in Tennessee State Prison, they'll tell you he got a purty mouth, or lies. Okay? It's the guy who doesn't want to pay his child support and would rather give it to one of these clowns up here to send him to prison.
Are not in fact liens. The lien is the underlying security agreement. These are simply notice filings. They are simple and skeletal instruments by design that serve one function, as Justice Kirby noted in 2011, writing for the Court of Appeals in the case of Regents Bank versus Brick Contractors LLC. Quote, the purpose of a financing statement is simply to provide sufficient notice to third parties to instigate further inquiry.
Instigate further inquiries. So, if you don't have your security agreement filed in the UCC file number, how is anybody going to know whether it's legit or not? Because the first thing you should do is file a UCC-1 notice that there is a security agreement. Hopefully you have a security agreement with a file number on it. Then you go back and you do your UCC-3 file. Okay, you can file ancillary documents with your UCC-1. So that's when you file your security agreement. Then you come back with your UCC-3 and hit the collateral. That's what you should do. okay? And you put all your instrumentation in the collateral box of your UCC1, which would be your security agreement, a hold harmless indemnity agreement if you have it, copyright notice, a power of attorney, whatever instruments that you want. You can do, if you're doing a private administrative process, you can put those instruments in there. Your 3 invoices, your notice of fault and opportunity, cure and contest, your notice of default, your affidavit of truth, your notarial protest. I can go on and on and on and on and on. That didn't happen, did it? Chris Hauser, you're a fraud, bro. That's all you're about is fraud, 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 fraud. And what do people that commit fraud do? They lie. And that's all you are, is a fraudulent liar. And I'm proving it.
Standing alone, unquote, they confer no rights. They function merely as a heads-up look, this debt might exist. In this way, they are more akin to a save-the-date card than the wedding invitation, a bookmark than the book, a shopping list than the actual sales receipt.
But even if it's a document, so you seem to agree that it is a document constituting evidence of a debt within the meaning of the valuation definition. So if that's the case, then isn't it really a factual question as to what the value of the debt is that the document is evidencing?
I think that there are 2 questions that are questions of law when we look at value of these documents. The first is,
Okay, she just got pinned down to the mat. So we're going to see if she can escape. Okay, that's what she's trying to do right now. She just got pinned down. Okay, you admitted that it's factual evidence that there's something there. Now the question is what is the value? Did they place a value in the collateral? So, did they? Absolutely. But let's see what his mental competency counsel has to say.
does it have any value at all? Is there value? My main contention about these documents is that they have no ascertainable value. The second question, I believe, is a question.
They have no ascertainable value. Yet, when somebody does a search and it pops up that you have a lien filed against you, whether it's legitimate or illegitimate, obviously that has value. Does it not? Because if you're out trying to buy a house or buy a car, or you're doing a credit application at the cell phone store and they run your credit and they find out you have a $4 million lien against you, whether it's valid or invalid, does that not have value? Value is an intrinsic term. Did you just abuse everybody's time? Now, somebody's got to go expend time and energy. Does that not have value?
The question of law is, if it has value, how is that value determined? Once those 2 questions of law are answered, I think a jury can decide what the value is based on legal guidance of if and.
And they did, folks. They had a jury trial, and the jury determined that Chris Hauser was guilty as on all counts.
How?
On the document, with you, they claim to be encumbering. Isn't that at least some evidence that can be submitted to the jury and let the jury decide whether it's sufficient or not to set a value that would meet the threshold of whatever felony it is?
Yes, Your Honor. I would like to make a very, very pertinent point here, though, is that a financing statement does not proclaim value through the words written in the collateral description. The collateral description does not define value of this instrument. Collateral, as we know, is simply the property that secures the debt. If this is a document evidencing an indebtedness, then 39-11-106 tells us.
Okay, did I not show you the Court of Criminal Appeals opinion where it expressed distinctly what was in the collateral box? Did they not ask for lawful currency? or US dollars? Did they not? Okay. When they go back and they read the transcripts, okay, which would be the court reporter's record for this hearing, and they're reading it word for word, okay, and it's not going to be the justices, it's going to be their paralegals and their law clerks. They're going to eviscerate her testimony. They're going to chop it up, dice it up, and use it against her. And Chris, you're going to get roasted by the Tennessee Supreme Court. They are going to issue a scathing memorandum of opinion upholding the lower court's opinion. They are going to expound upon the seriousness of the offense to deter others from committing the same offense.
That we have to look at the size of the loan. The collateral description is not the size of the.
Okay, loan. Where in the record is the word loan? Where in the collateral description is the word loan? There are no loans here. These are liens. So, Emmy, girl, you just inserted Chris's gun in your mouth and you pulled the trigger and blew your brains out in front of the court.
Loan. The size of the loan is better reflected, if this court looks at it that way, in the principal maximum indebtedness line item, which in every single instrument filed in this case read $0.00. Collateral belongs to the debtor, and any value of this instrument would be defined as the size of the debt, not the collateral. Mr. Nathan Burton, a trial witness for this.
You hear her misspeaking?
Thank you.
Size of the debt, not value of the debt. Lien, loan. All right, this is the state's attorney, and this guy, I'm not going to play him. Chris said that all he did was regurgitate everything he did in front of the Court of Criminal Appeals. Well, you know what? If I'm going to use sports as an analogy. If I have a starting lineup for baseball and I'm just like killing it, winning game after game after game, and I'm squashing my opponents, why would I change my lineup? So if I was playing football, and everybody knows who Tom Brady is, and of course he's way past his prime, but he's still a pretty good quarterback. Tom Brady's winning games for me. Why would I pull him and put in somebody who's not as good? Doesn't make any sense, does it? So, nowhere in that testimony of Emmy Ray Tennant did you hear her once mention the word jurisdiction. Did you? I didn't. I listened very carefully. So, when we hear Chris Hauser state on and for the record, and let me go pull that up. Yeah, reduce that. John. Right? If you did, that would mean you submitted to their jurisdiction 5 times. I Apparently you do not in cases, Chris. You state that you get them thrown out for lack of jurisdiction. This is Chris Hauser, kids, right here. Chris Hauser. Is this Chris Hauser's profile? Is this Chris Hauser? Just want to make sure I'm not picking on anybody. And see, we're all friends here. There's Jesse, there's Catherine, there's Erica, there's Kim Hutto. She's actually been on my show. So there's Derek Gonzalez. Been on his Zooms. So is this not Chris Hauser's posting? Because I do not see anywhere where Chris is challenging jurisdiction. Don't see it. All I see is a fraudulent post. And I've showed you guys over and over and over and over and over. Chris Hauser is a liar. He's a fraud. If y'all want to continue to follow a fraud and a liar, hey, more power to you. Okay? It's like he told you, you can run in a dealership, any dealership in the United States, and take a 1099A and purchase a vehicle and have that vehicle or have it paid off by the U.S. Treasury in 45 days. Anyone, again, I submit out there to the public realm, to the sphere of everybody, show me the proof that it works. Because Chris Hauser is full of shit. Am I not right? I proved it over and over and over and over again. And Chris, I'm going to roast you, bro. Tell you, I get a piece of black charcoal on my spit. I'm going to roast you. Every time you open your mouth, I'm going to come check you. And I'm going to make sure everything that you're saying, 100% absolute truth. I'm going to hold you accountable for your actions and your words. Bet that, bro. Okay? I'm going to put you in the circle and we're going to hold you accountable. If you don't know what that means, well, you better go get you some behavioral counseling. All right? Now, for those of you who've continued to watch this live, you can hit the like button or hit the dislike button. I don't care, okay? I like it actually when I do get some dislikes because that means people have watched my video and they don't like me, they don't like my topic, they don't like my name, I don't know what they don't like. I have no idea. I don't care. I'm not here to impress you. You're not going to change my world. So when I go walk outside today and get in that gorgeous Texas sunshine, what you do in my channel has no effect on the rest of my life. I don't care whether you like me. I don't care whether you're my friend. I'm not here to make friends. I'm not here to impress people. I'm not here to become famous. I don't care. Okay? I'm here to save one person. That's all I want to do. One person. If I can save one person from wasting time and energy, then I've done my job. Okay? I've protected humanity. Okay? Yeah. I'm sure we're all exhausted with Chris Hauser's bullshit. Yeah, I agree 100% because it's bullshit. I'm going to call him out for the fraud that he is. I'm sorry. I'm just going to do it. I'm not going to not do it. And I hope I'm providing a service to everybody. Chris Hauser's a fraud. He's a liar. I've caught him in countless lies. Patricia, you are, you're more than welcome to stay. You're more than welcome to leave. I just have a problem with people who present themselves as gurus, who make false allegations, who clearly state lies, lie after lie after lie, who want to call me names and belittle me, which, like I said, it has no effect on my life and my existence. It just doesn't. So I could care less. Chris, you can call me whatever you want. If you don't think I've been called a whole lot worse, bro, what did you do in prison? Okay. I guess you were the bend over boy or something. I don't know. Because, um, we are here to further educate you. But as I've said before, I push process that I do not know that work successfully, me personally. You might find other people in my Telegram group who do push processes. I haven't vetted them. I don't endorse them. I don't endorse anything anybody else does, except my own experience. When I do it, I try it. It fails or succeeds, I do a video on it, and I present it for you to do. You can emulate it. You don't have to emulate it. If you see something that you want, instruments that I use in my process for the things that I've done, I'll send them to you for free. No problem. Email me, hit me up on Telegram. Okay? And that's pretty much it. So you can like, you can subscribe, you can share the video, hit the notification bell when I put out new videos. Hopefully, this will be the last video I do on Chris Hauser. Okay? Hopefully, Chris Hauser will listen and go sit down somewhere and shut the fuck up, because you're a liar and fraud, and I've exposed you to God and everybody. So, yeah, I'd like to get back on some like real topics and subjects and have guests on here that would like to talk about their experiences doing the different venues of this process, and not talk about a fraud and a liar who wants to belittle me and my associates. Because it's not going to happen, bro. I'm going to expose you for who you are. And I think I've done that repeatedly, over and over and over and over. So, Chris, you go have a nice day. Hopefully we won't see you anymore, because, I used to be in the car industry. I told you guys that. And you have really fucked that industry up. Because anybody who thinks they're going to walk into a new car dealership with a 1099A and purchase a vehicle, guess what? You can, even if you get it to work multiple times on a different level, i.e. utility bills, credit cards, mortgage, rent, whatever, okay? You're going to walk into a dealership, and as soon as you say 1099A, they're going to like, nope, our legal department doesn't allow that. We accept cash, cashier's checks, and wire transfers. Or we can get you financed if you got a down payment or a trade-in. That's what you're going to hear. So when you go into the dealership and you mention 1099A and they like turn you around and push you out the door, I want you to remember one thing. You heard it from that guy on that show that Chris Hauser did that. Okay? Chris Hauser did that. So you can thank Chris Hauser for that. So even if you do get the 1099A process to work effectively, time after time after time, and then you're ready to go get you a car, and you try to use the same process and get turned down, thank Chris Hauser. Yeah, that's what happens when you follow fraudulent gurus who claim that a process is their process that I've shown been around at least since 2009. Again, I proved you a fraud, Chris. So with that, thank you for joining me on this beautiful, lovely Texas spring day, because it's still spring. I'm going to resign for today. I'm going to answer phone calls, texts, emails, and I'm going to get outside and go enjoy this day. It is lovely, lovely, lovely. And with all that, kids, I really appreciate you being here. Thank you for watching this video. I hope you learned something and I enlightened you. You're more than welcome to leave my Telegram channel. You're more than welcome to unsubscribe to this channel. You know, but if you want to stick around, hey, I'll be more than happy to have you, because we are going to get to the end of the road. That I can assure you. And I'm working on that every day diligently. Okay? And if anybody's going to make the 1099A process work to go get a vehicle, it's going to be me, because I'm doing it the correct way. I'm coming correct. Absolutely. Believe that. Okay? I know owners of dealerships, so I'm able to go in to speak to the owners, and I've done it. I'm going to do it again, and I'm going to make it work, whatever it takes. If it takes a day or it takes 90 days, I'm going to get it to work, one way or another. Absolutely. So you can stick around for that, or you can leave. I'm not tripping. Turn me off. Go away. Go play with Chris. Okay? Chris cannot hold his side of the debate. Chris has left the battlefield. What happens when you leave the battlefield? You're a loser. Bye, Chris. With that, thanks for watching. Appreciate you. The Floyd Show. I'm Fearless Floyd Show on Telegram. I'm on. I need to upload some more videos there. Down, and I'll build my website. Eventually, I'll have some merchandise that y'all can buy if y'all want to buy it. I'm not trying to make any money. I got money. I'm not a millionaire. I got money. I'm good. Thanks, kids. Y'all have a good day. Appreciate you watching.